Okay, good morning. I'm going to go ahead and get this started. I'm going to mute everybody just to block out any background noise that might be there. If you have a question about what we're talking about, just to unmute yourself and you'll be able to ask me a question. So let me just mute people. Okay, we're going to pick up where we left off last week with paragraph 3 of the contract. And once again, today's session is just going back to the basics. So we're going through the questions. Ask Larry's on Tuesday. This is a session for understanding the basics of real estate and the contract. Okay? So before I actually look at paragraph 3, I pulled out from the real estate board rules and regs a few things in reference to paragraph 3 that you shouldn't be doing. And this is under actions constituting failure to act as a real estate broker or salesperson in such a manner as to safeguard the interest of the public, including but not limited to the following. Okay, and G is licensee failing to submit to the broker in a timely manner all earnest money deposits, contracts, listing agreements, deeds of lease, or any other documents for which the broker has oversight responsibility. If you don't turn this stuff in to your office in a timely manner, real estate board could fine you for failing to act as a real estate broker in the best as so as to safeguard the interest of the public. Our rule has to be into the firm within 3 days of ratification, so that it can clear the bank in the 5 business banking days required by law. Also,
Larry?
yes.
Sorry, where are you reading from? I mean, what are you referencing?
I'm referencing the real estate board rules and regs. I'm just telling you what's in them, okay? And then I'm going to go back to the contract.
Okay.
Okay. If you want, you can download the DPOR rules and regs, and you can find this stuff in there. But I just want to share a few things with you that could cause. DPOR really considers paragraph 3 a very serious offense. So I want to make sure that everybody understands where it's coming from when we talk about this. Listen to this one. A licensee knowingly providing the broker with an earnest money deposit check from an account with insufficient funds. What does that mean? Well, if the owner tells you, the buyer tells you, I have to move some things around, I need you to hold that check, well, then you've accepted a check that you know has insufficient funds. If you hold that check and then turn it in, you could be in violation of the real estate board rules and regs, especially if that check isn't good, okay? Then they also, when it comes to these checks, under section 12, which they call actions constituting engaging in improper, fraudulent, or dishonest conduct, including but not limited to. Now, listen to these. Licensees submitting copies of the same earnest money deposit check for inclusion with multiple offers. So if you have someone that wants to write an offer on more than one property, they give you a check for $10,000 earnest money. You make a copy of it and you attach it to each offer. That is a violation of DPOR rules and regs, and that's failing to safeguard the interest of the public, which is a pretty serious charge. Another one, a licensee representing an offers he received the earnest money deposit when he has not, or he knows the check is worthless. So once again, if I tell you I have to move some things around, the check you received is worthless, that's a violation, okay? Or I forgot my checkbook and I said, well, I'll bring you the check tomorrow. You go ahead and write in your contract that you received the check and present the offer and you don't have the check, direct violation of DPOR rules. Another one is a licensee misrepresenting who is holding the earnest money deposit. Whoever is reflected in the contract is who has to be the one holding the deposits. So let's take a look at paragraph 3, and what I tell you I think will make more sense now that you know what the regulations state. Everyone with me in the sales contract, page 1 of the contract, paragraph 3, deposit. Everyone there? Okay. Buyer's deposit, and once again, we're just going through this line by line, so if you have a question, stop me. In the amount of, if it's a check, they add it to this contract now, bank wired funds.
Sorry, I downloaded the attachment. What page are you on of the 86?
I'm on page 1 of the sales contract.
Residential sales contract, page 1?
Correct.
And then paragraph 3?
Paragraph 3.
Okay.
Okay. So, and if you didn't catch last week's session on paragraphs 1 and 2, that was recorded. You can go back and pick that up on our YouTube channel. Okay. So buyer's deposit in the amount of bank wired funds. Most real estate companies are not going to use bank wired funds. You would have to probably be making that deposit with the title company like RTS. Matter of fact, through this pandemic, that's how you were handling these deposits. So if you had a deposit in this contract and it said Fairfax Realty of Tyson's, but the check was bank wired to RTS to hold, that would be a violation of the real estate board rules and regs. You'd actually have to go back, get everybody to initial the change that it was going to be held by RTS. Okay. Now, and or a note due and payable on, and there would be a date there. Now, what they're talking about, if I was a buyer, I might say to you, look, I want a home inspection in my contract. I'll give you $1,000 earnest money right now, and I'll give you a note for $9,900 to be payable upon the removal of my home inspection contingency. And the reason I might do that, if I give you $10,000, that's all I had, then I might, and I void my contract, it might be a week or two before I got my money back to be able to go out and buy another home, because the check in the escrow account, once it gets into that escrow account, it belongs to both buyer and seller. It's no longer just the buyer's money. So until that money is released, you cannot use money already in an escrow account to write another check just because you voided the contract on home inspection contingency. So if they void the contract and everybody signed the release, then I've always recommended the brokers cut that check back to the buyer and let the buyer write a new contract for the new property. But it says you can't use the same check for more than one property. And if it's in an escrow account and not been released, it's already pledged to a property. So those are some of the problems that we see that get reported to DPOR on a regular basis. Okay, shall be held by escrow agent. Then remember, when the words are capitalized, as setting a definition. So whatever name goes in shall be held by escrow agent. That's where that check has to be deposited. If it's deposited anywhere else, that would be misrepresenting who's holding the check. Any questions about that?
Yeah.
Okay.
If I have a check for one property A, my contract doesn't go through, I can use that check for other property or not without any order?
Once that property didn't go through, yes, you could reuse the check because it's it's not pledged to a property.
Okay, thank you.
And remember, when your contracts are not accepted, and you're a buyer's agent, and you need to either send an email to the listing agent saying our offer is now withdrawn, because unless there was a formal rejection by the seller, that contract is still floating around out there. So always withdraw your offer if it's been rejected. I know that sounds silly. They've called and they've said, well, we already accepted another offer. But unless you've withdrawn your offer, it's still a valid offer that could be accepted later. You listing agents, when your contract is rejected, write rejected on it and have the sellers initial it, send it back to the other side so that they don't come back later and try to claim they had an active contract, okay? So once that contract is no longer in existence, then the check is only being used for one property. That is fine. Okay?
But if
no buts, no buts. When
no,
you say
my
but,
question.
you're telling me, no, listen to me. Don't ever use the word but with me because you just told me everything I said didn't matter. Now listen to you. Use the word and. Okay. And now I'll listen to you. Okay. And
if,
what?
If I have a contract for property A, and client wants to put the contract for property B, so I can do that or no? Before ratification. Before ratification.
You can, but you can't use the same check for both properties.
No, contract is not ratified yet. So
it doesn't matter.
Yeah.
The law said submitting copies of the same earnest money deposit check with multiple offers, not multiple contracts.
I see. Okay. All right.
So the law says offers, right?
Okay.
So
thank you.
So that's why I might use a note to be redeemed maybe within 24 hours. That way I'm not using the same check for more than one property.
Okay, thank you.
Okay. Now, it goes on to say here in paragraph 3, buyer has or has delivered or will deliver, right? What does that mean to the escrow agent? So you're representing the buyer. They made the check out to Fairfax Realty of Tyson's, for instance, all right? They hand the check to you, okay? Have they given it to the escrow agent? Well, if the check's made out to Fairfax Realty and you work with Fairfax Realty, then you would check the box as delivered. But what if it says RTS? They give you the check, it's made out to RTS. Would you check the box that the buyer has delivered the deposit to the escrow agent or will deliver? You'd have to choose will deliver because you're not RTS, you don't work for RTS, okay? What if they asked you to hold the check because they have to move some stuff around? Well, then they will deliver the deposit to the escrow agent by X number of days. You don't accept the check because the check's not good. You understand what I'm saying? And these are problems that come up at DPOR all the time. Okay? You got to be really careful with these earnest money deposits. That's their hot button for some reason. All right? So if any of the things we discussed, the money's not there, they didn't really give you the check, they're gonna, they need to bring it back, then they haven't delivered the check, they will deliver. And you can't misrepresent who's holding the check. So if they hand you the check made out to RTS Title and say it's been delivered, you're misrepresenting who's got the check. I know that's splitting hairs, but that's the way they look at it, okay? Now, it says, let's say they will deliver the deposit to you by 5 days after date of ratification, okay? What happens if by 9 p.m., 5 days later, they have not delivered a check to you? What must you do? Well, now you must contact the listing broker and tell them, or listing agent, they have not redeemed the check. We will continue to try to collect it. Now, a lot of people say that is a default under the contract. It is not a default. It's a breach of a contractual term, okay? Not a default. So they could cure that, but we're not going to get that deep into it. If this happens, make sure you talk to your broker, all right? Goes on to say, if the escrow agent is a Virginia Real Estate Board licensee, which you are, right? The parties direct the escrow agent to place the deposit in an escrow account by the end of the 5th business banking day following receipt or following date of ratification, whichever is later. So what does this mean? What it means is if they hand you a check, I usually ask them, is this check good? Because I can't accept a bad check. If it's good and this contract is ratified, then I'm going to immediately be turning this check into my office, right? However, if it said will be delivered in 5 days, well, then that would be 5 business banking days following the receipt. So if they bring it to me on the 5th day, then we have 5 more days from the delivery that was called for in the contract. If it called for the agent, for them to deliver the check to you in 5 days, they bring you the check in 3 days. Well, the 5 days start then, okay? The first day being the next day. Even though you said 5 days, that doesn't, it's 5 days from the receipt or the date of ratification. If you already have the check, doesn't call for it to be held, and all parties agree, turn it in. If not, it's within 5 days after the receipt. Any problems with that?
Yeah.
Okay.
In case the real estate agent doesn't know that check is bounced or not bounced, so who's going to be responsible?
Well, if you knew
Yeah.
the check was not good, you're going to be responsible. If you didn't know the check wasn't good, then it's going to be a breach of contract between buyer and seller.
Okay, thank you.
But for you to accept one where I tell you, I don't have the money in the bank, I've got to move some stuff around, you know what I mean? I've heard that one many times in my career. Then when do you think you could have things moved around? Well, 5 days. Then I'm going to write in this contract, they will deliver the deposit to me in 5 days. Otherwise, I've accepted a check that I knew was not good because it could not be cashed. Within, okay?
No.
All right with that?
Yes.
Yeah. And the check's made out to RTS Title. They hand it to you. You write in the contract that it has been delivered, which it hasn't been. All right. How many days does RTS Title have to get it into the bank? If you're holding on to the check, you're going to send it over to RTS Title. How many days do they have to get it into the bank?
5 days?
It's not 5 days, okay? Because they're not licensed by VREB. The 5 days is a real estate board rule and reg, not for escrow companies like RTS. So it says if escrow agent is not a VREB licensee, deposit will be placed in an escrow account of the escrow agent after date of ratification in conformance with the laws and regulations of Virginia. So I asked Louisa about this last week, and she said, well, they don't have any set days. They have to do it in a reasonable amount of time. But if you're holding on to the check that's made out to the title company, and for some reason you've held on to it for 3 days, and this buyer decided they don't want this property, and they stop payment on that check, do you think you have a problem? Yeah, you have a big problem. Yes. Because you misrepresented who was holding the check. You had it, okay? And they misrepresented in their contract that they had already delivered it to RTS. About the only way they could check that they have already delivered it to the title company is to give it to the title company before they even start out looking at houses. So be very careful with how you fill out this paragraph. If VA financing applies, okay, as required by Title 38.
I'm sorry, how can we be sure that check is good if we gave this check to the title company?
The title company will let you know if it's not good.
Yeah, but you said it's not certain period of time when the title company is supposed to put it in the bank.
Well, my suggestion would be if you should never have a check in your hand, but if you do and you deliver it to the title company, then I would suggest that you get some kind of a acknowledgement that they have received a check. Okay. Now, you know, it's out of your hands and your responsibility. Okay.
But even though if the title company found that the check bounced back or not going to be clear,
if the check was dishonored, they will let you know, believe me.
but
And
not right away, right?
They will let the agent know, they will let the seller know, and they will definitely let the buyer know. Okay. The point here is, don't misrepresent that it's been delivered if you're holding on to the check, because you don't work for RTS. Okay. So anytime that I write a contract and it's made out to RTS title, I make a copy of the check to attach to the contract with a notation that this is a copy of the check that the buyer will deliver to the escrow agent within 3 days after date of ratification. So I make sure the buyer understands they have to bring it over. Now, another thing I want to cover here before we finish reading this paragraph. If you are going to submit a copy of your offer via internet to the listing agent, and you are including a copy of the earnest money deposit check, think about what you're sending through an unsecure internet system. You sent a copy of my check with my signature, my name, my address, my routing number, and my bank account number. Don't do that, folks. Redact the information. And when I say that, don't cross it out on the check itself. Take and make a copy of the check, cross out all the information that the other side doesn't need to see. Okay? Because there's a lot of fraud that takes place over the internet, and you don't want to be the person that made it so easy for it to be done.
Good
Everybody,
advice.
everybody understand what I'm saying?
Yeah.
Okay. Now, this account may be interest bearing.
What do you think we should cross it? The check, like
I cross out the routing.
number?
I cross out
Routing
everything,
number.
but I cross out
Routing-
everything but their name, their actual name, and the amount of the money.
All right, sir. Thank you.
Okay. That's all they need to see, right? This account may be interest bearing, and all parties waive any claim to interest resulting from the deposit, which makes sense. I mean, what does it pay? 1/10 of 1% anyway, if it was an interest bearing. The deposit shall be held in escrow until, okay, 1, credited towards the sales price at settlement. Now, a little warning. If you're holding the check at your real estate company for $10,000 earnest money, and the commission in the transaction is only going to be $7,500, then you need to contact the office in time enough for them to get a check cut to the title company for the other $2,500. And most title companies aren't going to accept a personal check. They're going to want some kind of, funds that are certified or whatever. So if you're holding more, you've got to remember well in advance to request that from your company to be gotten to the title company, or maybe they just wire it in there, whatever they're going to do. But that money needs to be there for the settlement to take place. You understand what I'm saying? Good. Or 2, all parties have agreed in writing to its disposition. There is a release of the contract form that we'll look at when we get to addendums that needs to be signed by all parties. The brokers don't sign it, agents don't sign it, because under law, we're not entitled to any of it anyway unless all parties want to agree to give us some of it. 3, a court of competent jurisdiction orders disbursement when all appeal periods have expired. 4, disposed of in any other manner authorized by law. So if the broker, in their opinion, thinks the money should go to a certain party in accordance with the terms of the contract, then they could send out what we call a 15-day protest letter. Okay, 15-day protest letter. If no one protests, this is what we're going to do with the earnest money deposit, and they could cut a check to the party. Another one would be interpleading. The broker can say, I can't get the parties to agree, so here, court, I'm interpleading with you. Here's the money. You decide what happens to it. One other time that authorized by law, if I have a contract on a property and that property is foreclosed on, okay, the contract is now null and void. The broker can give the earnest money deposit check back to the purchaser unless they're also in default under the terms of the contract, which probably wouldn't happen in the case of a foreclosure. So that's what they're talking about in a manner authorized by law. Seller and buyer agree that the escrow agent will have no liability to any party on account of disbursement of the deposit or on account of failure to disperse deposit, except in the event of the escrow agent's gross negligence and willful misconduct. Quite frankly, as a broker, if I sent out a 15-day letter for protest period and no one protested, I would probably then interplead the money and send it to the court just to protect myself. But, you know, a broker could technically cut the check back. Any questions about that paragraph? Because that is the paragraph that DPOR is really, really tough on.
Yes, we have a question. I have a question about the paragraph. You had mentioned, I think it was during the first bullet where I didn't get, it wasn't quite clear on what you were saying about having to issue a check for $25,000 to the settlement company. What were you saying? I just need clarity on that. I think I missed something.
So you received a $10,000 earnest money deposit check and it's held by Fairfax Realty, whatever office, right?
Right.
Your total commission is only $7,500, right?
Okay.
So the commission that Fairfax Realty is entitled to is $7,500. We're holding $10,000. That other $2,500 is part of the closing cost and down payment of the buyer. So you need to, if your commission is less than the total check that's being held by the company, you need to get to your manager. They need to order this money to be dispersed from the escrow account, okay, to their general operating account. And then that check has to be gotten to the title company to be credited towards the purchaser because it's their money. Did that clarify it?
Okay, so that's if it's held by, if the earnest money is initially held by the brokerage.
Right. So
Okay.
if it's held by the title company, then they already have it. It doesn't affect us at all.
Okay, I think that's the part that I missed, who was holding it and why we needed to reconcile the difference. Okay, thank you.
Good, good. So anytime you have a question, need a clarification, please speak up like that, okay?
Yes.
Good. Okay, let's take a look at paragraph 4, settlement, okay? Seller and buyer will make full settlement in accordance with the terms of this contract on or with mutual consent before settlement date. So whatever date you put in there is settlement. If they want to settle early and everybody agrees, there still has to be an addendum or an amendment to the contract changing the date, okay? The flip of that is to also make sure that the title company can do it and also make sure the lender can do it because they have to send that 3-day right of receipt, that 3-day CD for you to be able to compare buyer to your loan estimate. My daughter went through this. She called me and she said, we moved up settlement. I said, explain that one to me, because she's in California. I said, have you received your CD yet from the lender? She said, no. I said, then how in the world did you guys agree to move up a settlement? You can't just agree to do something unless all parties can fall in line and do it. To change it in writing would have caused a default on her part in the contract, because she wouldn't have been able to settle. And as it turns out, that would have been the case. Okay? So it's okay to say we're going to move it, but make sure all parties involved in the transaction can do it, not just buyer and seller. Now, I got this call from a broker from another firm that I do some consulting for, and he said, the buyer settled today. The settlement's not supposed to be tomorrow, and the seller doesn't want to settle till tomorrow. Can they do that? And I said, well, your date was tomorrow, but tomorrow is a Saturday. Okay. And what does our contract say? It says its settlement date falls on a Saturday, Sunday, or legal holiday, then settlement will be on the prior business day. So the buyer and the buyer's agent were actually performing as to what the contract said. So please pull out your calendar, okay? Pull out your calendar before you write a date in here. Make sure it's not a Saturday or a Sunday or a holiday, because you're going to move it up a day or maybe 2 days, okay? So please check that out. Now, this paragraph deals with RESA, okay? Real Estate Settlement Agents Act, okay? It's what we used to call the Wet Settlement Act, but it's been changed to RESA, Real Estate Settlement Agents Act. Who has the right to choose the title company? The buyer.
The
Buyer.
buyer.
Okay? So the buyer has the right to choose the title company, period. Right? How many title companies can there be to a transaction?
2.
Only one. Okay? Only one title company.
How about
How many- how
split
many-
under-
I'm going to get, okay, that's a good question. How many attorneys can be involved?
2?
As many as you want.
Yeah.
Okay? So in a split settlement, the buyer selected the title company. That title company lawyer can't give that buyer any advice. Their only job, we'll read here, is clerical and administrative functions. If it's a split settlement, okay, then the seller is actually hiring an attorney to represent them. So it's a little technicality in our statute, but you would not put RTS representing the, in this, and then a split settlement MBH representing the seller. It would actually have to be the attorney for MBH is representing the seller, because they're not doing the administrative functions. They are actually going to be handling stuff on behalf of that seller, maybe preparing the deed, reviewing documents, and giving them legal advice. Okay? So when we read this paragraph, if you understand that, it might make it a little easier to understand and why the buyer has the right to choose the title company. Okay? And it says here, you have the right to select a settlement agent to handle the closing of this transaction. The settlement agent's role in closing your transaction involves the coordination of numerous administrative and clerical functions relating to the collection of documents and the collection and disbursement of funds required to carry out the terms of the contract between the parties. If part of the purchase price is financed, your lender will instruct the settlement agent as to the signing and recording of loan documents and disbursement of loan proceeds. Who actually prepares the CD for the settlement? Well, it's actually the lender, right? And they send this over to the title company to add the other costs to it, right? But very important here, no settlement agent can provide legal advice to any party to the transaction, except a settlement agent who is engaged in the private practice of law in Virginia and who has been retained or engaged by a party to the transaction for the purpose of providing legal services to that party. Okay? So the seller has the right to hire an attorney to represent them. Okay? If you want legal advice as a buyer, you can hire an attorney to give you legal advice. But the attorney doing the settlement is not going to be the party giving you legal advice. Does everybody understand that? I like to make sure the buyer and the seller understand when I talking to them that this party is not representing you as attorney. They're representing the transaction. Okay. Now, this is a really important paragraph in paragraph 4. Right? Variation by agreement. I would highlight this. The provisions of the Real Estate Settlement Agents Act may not be varied by agreement, and rights conferred by this chapter may not be waived. Your seller cannot say they must use my title company, or my attorney, or my settlement agent, or I'm not selling the house to them. That is a direct violation of law. Okay? I have the right to choose it. It cannot be waived or varied, even by agreement. So even if we agreed to it in writing in the contract, it's not enforceable. I still have the right to choose my own representation. Okay? Now, you can say in your listing, we prefer, okay? We recommend. You can't say must. And if the only reason you turn my contract down is I would not use your title company, that is a violation of statute, and there would be damages due if a buyer wanted to sue a seller. The seller may not require the use of a particular settlement agent as a condition of the sale of the property. Okay? Escrow, closing, and settlement service guidelines. The Virginia State Bar issues guidelines to help settlement agents avoid and prevent the unauthorized practice of law in connection with furnishing escrow, settlement, or closing services. They can't serve as your attorney in the transaction. Okay? You can download these and read them yourself, or you can actually get a copy of it, which it says here. As a party to a real estate transaction, you are entitled to receive a copy of these guidelines from your settlement agent upon request in accordance with the provisions of the Real Estate Settlement Agents Act. Okay? So if they want to really understand, they have the opportunity to do that. Buyer designates settlement agent. Okay? And they have to contact that settlement agent within 10 days of date of ratification to schedule settlement. We looked in the first day, we looked at what constitutes date of ratification, right? It's capitalized, it's defined in our sales contract in paragraph 31. Settlement agent shall order the title exam and survey if required. We had an instance where the buyer came through another company. They actually asked, gave their information to RTS, and then the other side wanted them to use their own title company. All this work was done, and the people said, no, we're going to use the other side. Well, once they asked for that person to start the title work, they could still change within 10 days, but they're going to be responsible for the cost of that work that the title agent has done.
I have a question, Larry.
Okay.
Say, oftentimes you might see in a listing that the agent might put in there, they do prefer a specific title company. And because we're in a competitive environment now, trying to get our contracts accepted, we go ahead and agree to that title company. We're representing the buyer. We don't want anything to stand in the way of us getting this, getting our contract ratified. So we agree to their title company, even though we know we don't want to use them. So we agree to it and get our contract ratified. Now, we can't submit an addendum to change the settlement agent, right?
Why not?
not an addendum, but actually not an addendum, a notice. Because since the buyer has the right to select the settlement agent, we can just submit a notice saying we are going to use a different title company.
I think you can. I would tell them to seek legal advice, but let's read this paragraph again, okay? May not be varied by agreement. What is a contract?
Agreement?
An agreement, okay? So, and the buyer has how many days to contact the title company to start the work?
10?
10. So my position would be, if they change within those 10 days, I think they have the right to do it.
Okay, yeah,
Now, the other side is going to be quite upset, right?
right.
And say you can't do it. Well, then, just refer them back to the RESA. It cannot be varied even by an agreement. Okay.
Mm-hmm.
So I would think they could do it. And I've had it happen before. How does a builder get you to use their title company?
They recommend you.
They promise some allowances. That's
okay,
why.
so they give you incentive, right?
Incentives.
Sure. So if I'm the listing agent and you ask for closing cost assistance for your buyer, okay, I'm probably going to suggest to the owner they consider adding a term that says, we agree to this contract, okay? You put in there you would use our attorney, okay? And I might add a clause that says, if all parties agree that if any term of this contract changes, okay, if the buyer changes any term in this contract, then the buyer forfeits the closing cost assistance. So if you send a notice over to me saying, well, we changed our mind, we're going to use our attorney, I'm going to say you have every right to do that, but you understand they just changed the term in the contract. Therefore, they're forfeiting their closing costs. Now, I'm not telling you can't do it, but I'm going to go with the rest of my contract. And that's basically how the builders get you to do it, because they can't say you must use it. It's against the law, right?
Larry, what the difference will be for the seller if the buyer chooses different company? If the settlement or all numbers the same, what's the reason to be against it?
Well, sometimes, how many sellers have you ever met that said right up front, they have to use this company? I've never met a seller that said they had to use this title company. Who usually wants them to use that title company?
Agent.
The agents. Okay, so let's get realistic. It's the agents that want it because they're comfortable with that company. They know how they work. They bend over backwards. I don't know, but it's usually the agents that are driving this. Now, when I worked for Merrill Lynch years ago, okay, we handled a tremendous amount of relocation, and Reese, Broom, and Diaz, okay, law firm handled all of our settlements. So if the transferee had already received most of their money and everything was over at Reese, Broom, and Diaz, they wanted everybody to settle at Reese, Broom, and Diaz just because everything was already done. Okay, so that might be a reason they wanted to do it, but very seldom is it the seller that insists on this or the buyer that insists on this, because a title company basically has to just do what? They have to numerous administrative and clerical functions, right? So, like I say, everybody still has the right to have their own attorney. It was a really convenience matter with Merrill Lynch because of the volume of paperwork that was already completed. Okay, so actually the seller had already signed all the transfer papers in in blank because they'd already received their money. So everything was sitting there ready to go. I can see that, but not most of the times. I think it's just the agents. Okay? Because you know how well a company works.
Larry,
Yes.
we have a 10 days to choose a settlement company, which is we agreed to go with the seller, but now we decided to go with our company. Do we have, I wasn't clear that, do we have to send anything to them?
I would
that
just
are-
I'd send a courtesy notice.
I see. Thank
But
you.
it doesn't require an addendum because you know,
Just a notice.
okay,
Thank you so
because they
much.
have the right to do it.
Purchaser, Larry, purchaser can have their own settlement company and purchaser, buyer and the seller.
Buyer chooses the title company.
And the seller can choose their own company.
They don't choose a company, they choose an attorney. So if they were going to use RTS attorney, well, here it would be Louisa, okay? So she could actually represent parties in a settlement. I just had Louisa represent us as an attorney in a stuff for our estate, okay? Even though it was being settled in a title company, it was an estate, my father's estate. I hired her as an attorney to represent and handle all the paperwork from this end. So what the attorney now would be doing for the seller is coordinating everything with the title company. They might actually prepare the deed to be sent to the title company. So they are actually performing then legal work for a party, not shuffling paperwork back and forth.
So title company or buyer, you say?
The buyer
Right.
chooses the title company, right?
No,
By law.
seller chooses their own attorney.
Seller would not choose a title company. They would choose an attorney. So if they wanted to go with RTS and the buyer had chosen MBH, well, RTS would not be the attorney. Louisa is the attorney for RTS. So your contract literally would say Louisa Miranda White, okay, represents the seller, okay, in this transaction. But they're not doing the settlement.
But they do not have to notify a buyer, or
Well,
they
you
do
would
have
notify them. So if you're going to do a split settlement, you would put in the other section of the contract that, you know, Louisa Miranda White is going to be a split settlement. And you know, how often do all parties come to settlement anymore?
not very rare.
Not very seldom, not very often,
Yeah.
right? Because
Yeah.
we're doing so many split settlements. So don't lose a lot of sleep over this. Just, you know, the technicality is title companies can't perform legal acts or give legal advice. So if you want legal advice in a transaction, you have to hire what?
Attorney.
An attorney. So you would hire the attorney of that firm that you're used to dealing with, or another attorney. You could literally have an attorney representing the buyer at the settlement table. You could have an attorney representing the seller at the settlement table, and you can have RTS handling the what? The settlement. So that if either party had a legal question, they could turn to their attorney, and the other attorneys would negotiate, because the title company's attorney handling the settlement can't negotiate items. I've been at settlement table where the attorney got up and said, look, when you guys work this out, call me. I've got other stuff to do. Okay? Because they can't handle a legal problem at the table.
But a buyer,
No buts.
okay. Buyer puts the contract. We know he submits the contract. He doesn't tell the seller that he's going to have their own attorney. He has to notify.
No, it says each party has the right to have what? An attorney. But if it's going to be a split settlement, we need to know who the other side is going to be, so the title company can coordinate with them to get all the paperwork.
Okay.
You don't hide it. I mean, we're trying to get this to settlement, not cause problems. Okay. Now, I didn't want to skip around much in this contract, but paragraph 20 of the contract, I'm just going to tell you what it says. We'll get there eventually. Paragraph 20 of the sales contract says that if the title work isn't ready, the attorney's title work isn't ready on the day of settlement, what happens to this contract? It's automatically extended for 10 business days.
10 business days.
So basically what, 2 weeks? And if it's still not ready, right, then who has the right to void the contract? The seller. Because the buyer had to contact their title company in X number of days to get this all started. And if they didn't do it, they caused the problem. Okay? So even though there's up to 10 days to schedule the settlement, if you have a 30-day settlement, you need to get this paperwork over right away. So tell them to make their mind up. Okay? Now, a little paragraph here that not too many people pay attention to. To facilitate settlement agents' preparation of various closing documents, including closing disclosure, buyer hereby authorizes settlement agent to send such closing disclosure to buyer by electronic means and agrees to provide settlement agents buyer's electronic mail address for that purpose only. If they do not have an email address, they just agreed in this contract to get one. Okay? And it might end up being through you, but they've agreed to do it. Otherwise, take that out. When my dad was alive, nothing was done electronic. Everything had to be done hard copy. So we literally took it out of the contract. That's the only way he would deal, was he wanted to see it in writing, face-to-face type stuff, you know, old school. So any questions about paragraph 4? Okay, I want to cover one more paragraph today, paragraph 5. The balance of the down payment will be paid on or before settlement date by certified or cashier's check or bank-wired funds as required by the settlement agent. They will tell you how to do it. No personal checks, okay? If they show up with a personal check and it's not certified funds, then the settlement recording isn't going to take place until that check clears, which could be 7 days. So you've got to stay on top of this. Make sure the bank is open on the day that they're going to need to get the check. They might have checked Veterans Day for settlement. Title company can do it, but the bank's not open to get the check, so they're going to have to get it in advance. You're going to have to stay on top of this, okay? An assignment of funds shall not be used without prior written consent of the seller. And I add to this, lender and title company. Okay? What is an assignment of funds? You've heard of something called coinciding settlements, correct?
Yes.
So a coinciding settlement is, I settle on the house I'm selling today. I'm going to settle on the one I'm buying this afternoon. I need the funds from that morning settlement to buy the afternoon. There's no way I'm going to have those funds to do it. Okay? So that would require an assignment of funds. And everybody's going to have to agree to that assignment of funds. Title companies, the lender, the buyer, the seller. So it says with the consent of the seller. Where do you get that consent? Well, if you go to page 25 of this contracts package, page 25, it's called Contingencies Clauses Addendum from NVAR. Okay. Settlement of buyer's property. And hopefully this paragraph was used, right? I'm not going to go over this in detail here, but it says here, seller will or will not accept an assignment of funds. See those boxes to be checked? So you have to use 25B if there's going to be an assignment of funds. and the seller has to agree here. The seller might agree if they don't need their money. But if they need their money to do another transaction, they're not going to agree. It's pretty hard today to coordinate coinciding settlements because each lender has to give a 3-day CD. There's always things that come up. So more than likely, what you will have is somebody settle on their property pre or post occupy another property so that they actually have the funds to bring to the table. Heard me talk before. I do not like I don't like post occupancy or pre occupancy of a property. To me, it's the kiss of death. It's caused more problems than all the other problems I've seen in all my years of management in real estate. Okay. Any
Larry,
questions? Yes.
Can you hear me, Larry?
Yes.
This is Ken Wright. You remember my coach Epley used to coach you when you was a wide receiver at Virginia?
You're breaking up a little bit on me. What is it?
I said Coach Epley used to coach you when you were a wide receiver at Virginia. You remember?
Yes.
From my high school? Okay.
Yes.
Where is that assignment of funds? That's in the contingency clauses addendum?
It's if you downloaded the contracts package.
Yeah, I'm looking at it right now.
It is back on page 25. The page number's at the top.
Okay.
Okay. And
yeah,
you'll see settlement of buyer's property.
What I'm looking at page 25 is I'm looking at page 25, 86. You're talking about the top, right?
You
I'm on the paragraph 14 of the contract.
Did you download today's package and not the one we sent with all the other stuff in it?
I did. It has 86 pages. And right now I'm looking at page 25.
No, 86 pages is the other package.
Oh, I'm sorry.
There's that's the one we use on Tuesdays. This is a contract package that was sent separate, and it has all the forms that I use when I teach at the board.
So yeah, okay, but it's in the contingency clauses addendum, right, for the assignment
yes,
funds?
it's the contingencies and clauses addendum for NVAR.
Okay, I'll find it. Yeah, I'll find it. Thanks.
And so there's a package that I'm using for this line by line sessions that we're going to go through that has 50-some pages, and it's just the forms that we use with the in my class at NVAR.
Okay, great.
Okay.
Okay.
Good. Any other questions?
Yes.
Yes, Mr. Larry, you saying earlier about if I represent, for example, the buyer and he's interested about 2 properties and we submit the offer for 2 properties with different earnest money checks.
There should be a separate check for each property. Yes. You shouldn't be making a copy of the check and attaching it to 2 different offers.
Yes, but in the instance, for example, if we get ratified both contracts, then we have to choose one of the things to void the contract of one of them, or?
Yeah, you would void the other contract immediately.
Immediately, okay. But you have to use the reason, isn't it?
You don't have to give a reason. You just say, the purchasers decide to withdraw their offer.
Okay, all right. Thank you very much.
Okay, and remember that the board's rules and regulations say a licensee submitting copies of the same earnest money deposit check for inclusion with multiple offers, not contract, but multiple offers.
Okay.
So that's why they have that option to use a note in that paragraph. And quite frankly, if we're in paragraph 3 and you send over that you have a note that will be redeemed at some time in the future, most agents are going to freak out because they do not understand. And quite frankly, I would rather have somebody give me a note than a check. You can't stop payment on a note, and a note can't bounce, and I can go to court and enforce it. So I don't have a problem with notes. We used them quite a bit back in the old days. I'm talking 40 years ago. But most people freak out if there's not a check and somebody mentions the use of a note.
Yes, sir.
Are you seeing people use the note now more regularly?
No.
I know you said, okay.
No, I would if I was a buyer, but no, they're not. And most agents have no clue what a note is anyway. okay? It's just a promise to pay. Why would, think about it. Why would you want to tie all your money up in a property where you have all these inspections to be done and you can void your contract, and unless the seller agrees to sign the release, the broker can't give the money back. So, and the seller's upset because you voided their contract and wants to play hardball. All my money's tied up. I can't buy another property. So,
Larry, what is a note?
Doesn't happen that often. A note is just a promissory note. You get them over at Office Depot or Staples or whatever. It's just a promise to pay. NVAR used to have them on their site. They pulled them off. It's just, I promised to pay at such and such time and whatever.
Somebody have to notarize it?
No.
It just says signed it. It looked like a letter. It just says signed it, and then you put it part of the contract?
Yeah, you're better off using a form.
This form exists in our library.
Do what?
In our library, Northern Virginia Association of Realtors. This form notes.
No, they don't have notes in that anymore. They used to in the old days. You're probably never going to be faced with it. I'm just saying, if I was a buyer, I'm a little different because I understand what's going on. Most buyers don't. Okay, so I'm headed to Florida.
You prefer to be given note or a check as a buyer?
Well, as far as I'm concerned, I would rather have the note, but most agents wouldn't, and most agents would tell a buyer that that's a problem because they didn't give a check. So you don't want to weaken your contract. Let's think about this. If there's 5 offers on your listing, 1 calls for a note, the other 4 have a check. Which one are you probably going to kick out first as a listing agent?
The note.
The note. You've had a listing for 9 months. You've had no action. You finally get a contract in, and it has a note. What are you going to tell the seller about that note?
Accept.
That's the best contract I've ever seen. Let's take that one. So it's a function of the market. If you're in a multi-contract presentation, you got to try to keep it as clean as possible. But if a property's been out there forever, you can get a whole lot more, from the other side than before. So it's a function of the market. Okay. Now I am hitting.
Larry.
Okay. Yes.
The number 5, down payment required by the settlement agent. They can say wired payment 1 day before settlement. They can say that, or we have to go by cashier check. We can give cashier check.
Well, they can't say it has to be wired 1 day, but they can require bank wired funds.
Wired fund.
Okay.
So we can do the certified check, right? Cashier certified check.
Yeah.
Okay. Thank you.
Okay. Now I'm headed back to Florida on Sunday. So while I'm in Florida, we're going to do classes on Monday and Wednesday instead of Tuesday and Thursdays. Okay. So Monday will be Ask Larry. Wednesdays will be this until I'm physically back into the area because I have other obligations and things I want to do on Tuesdays and Thursdays. So they will send out a notice, when we're holding them. We will start with paragraph 6, we'll keep working our way through this contract until we get to the end of it and look at the addendum forms. All right. Any other questions today? Good group of people. Spread the word. Let them know this is going on. I think you can pick up some good little tips here as we go through.
So it's Monday on Thursday, right?
Next week will be Monday and Wednesday.
Wednesday. Thank you.
But they will send out a note. Johanna, you have something you want to say to them?
Yes, Larry, just to remind all the agents from Tyson's and Herndon that the earnest money deposit cannot be brought by check or sent to Fairfax Realty. It must go to Realty Title of Tyson's and it must be wired.
Okay.
Yes.
So you need to reflect that in your contract so that you don't misrepresent. Okay. Anything else?
No, we'll send the new notice of your new classes when they are. They will start getting it tomorrow. Okay.
Okay. great.
So
And it was a
Monday
great
will-
class.
yeah, Monday will be the regular class like a residential contract, and Wednesday will be other one.
Wednesday will be the contract.
Okay, Monday will be, okay.
Monday will
I got
be
it.
Ask Larry and whatever I want to
Okay.
talk about,
Okay,
or
thank you.
whatever you want to ask. Okay?
Thank you.
All right. Thank
you.
everybody for attending. I appreciate it. I know the managers appreciate it because we'll get better contracts written if we know what's in it.
Thank you so much.
Thank you, Larry.
Thank you.